Hello, Senator Sessions.
Hello.
I've enjoyed working with you over the last 6 years and always found you to be someone who treats colleagues, regardless of differing viewpoints, with dignity and respect. You've taught me a great deal in the 6 years I've been here, and I've appreciated the opportunity to work with you. I think a lot of this has to do with the fact that we're both lawyers, although being a lawyer around here, certainly having a law degree is not unusual. One of the things that sets you apart and makes you different, I get the sense from you that you think of yourself not so much as a senator who used to be a lawyer, but as a lawyer who is currently serving as a senator. And I think that's an important thing, especially for someone who's been named to be the next Attorney General of the United States. Even though you and I have never had the opportunity to discuss the intricacies of the rule against perpetuities or the difference between the doctrine of worthier title and the rule in Shelley's case, I get the sense that you would eagerly engage in such banter when occasion arises. So maybe in a subsequent round we'll have the opportunity to do that. But this does raise a discussion that I'd like to have with you about the role of the lawyer. As you know, a lawyer understands who his or her client is. Anytime you are acting as a lawyer, you've got a client. This is a simple thing if you're representing an individual, because in almost every instance, unless the client is incapacitated, you know who the client is. The client has one mouthpiece, one voice, and you know what the interests of that client are, and you can evaluate those based on the interests expressed by the client. It gets a little more complicated when you're representing a corporate entity. Typically, you'll interact either with a general counsel or with a chief executive officer. The bigger an entity gets, the more complex it gets. There might be some ripples in this relationship between the lawyer and the client. In the case of the U.S. government and the Attorney General's representation of that client, this is a particularly big and powerful client. And that client has many interests. In a sense, the client is, of course, the United States of America, but at the same time, the Attorney General is there put in place by the President of the United States and serves at the pleasure of the President of the United States. And so, in that respect, the Attorney General has several interests to balance and must at once regard him or herself as a member of the President's cabinet, remembering how the Attorney General got there and can be removed at any moment by the President. And at the same time, the Attorney General has the obligation to be independent, to provide an independent source of analysis for the President and for the President's team and cabinet. How do you understand these things as a former U.S. attorney, as a former line prosecutor, and as a senator who served on the Judiciary Committee? You've had a lot of opportunities to observe this process. How do you see the proper balancing between all these interests from the standpoint of the Attorney General?
That's a very insightful or probing question, and it touches on a lot of the important issues that we, as Attorney General, would need to deal with. There are even sometimes these government agencies are like foreign countries. They negotiate memorandums of understanding that are akin to a treaty. Actually, they can't seem to work together oftentimes in an effective way. And so the Attorney General is required to provide opinions on that. The Attorney General ultimately owes his loyalty to the integrity of the American people and to the fidelity to the Constitution and the legitimate laws of the country. That's what he's ultimately required to do. However, every Attorney General that has been appointed by a president, or they wouldn't become Attorney General, and they've been confirmed by the Senate, or they wouldn't be made Attorney General. And so they do understand, I think, that if a president wants to accomplish a goal that he or she believes in deeply, then you should help them do it in a lawful way, but make clear and object if it's an unlawful action. That helps the president avoid difficulty. It's the ultimate loyalty to him. And you hope that a president, and I hope President-elect Trump has confidence in me so that if I give him advice that something can be done or can't be done, that he would respect that. That's an important relationship too. But ultimately, you are bound by the laws of the country.
Some of that, I assume, could come into play when you're dealing with a politically sensitive case, and with a case that is politically sensitive because it relates to a member of the administration or to the interplay between the executive branch and the legislative branch, for example. In some of those instances, there can be calls for a special prosecutor. On the one hand, this is a way of taking the Attorney General out of the equation so that it can be handled in a manner that reflects a degree of separation between the administration and the case. On the other hand, there are constitutional questions that are sometimes raised, and sometimes people argue that this places too much of a presumption that the special prosecutor will seek an indictment in order to justify the expense and the time put into appointing a special prosecutor. For reasons that relate to the complexity of these considerations, there are, of course, guidelines in place that can help guide the determination to be made by the Attorney General as to when, whether, how to put in place a special prosecutor. But even within these guidelines, there's a lot of flexibility, a lot of discretion in the hands of the Attorney General in deciding how to do that. Do you have anything that you would follow? What can you tell us about what considerations you would consider in deciding whether or not to appoint a special prosecutor?
Well, it is not a little matter. It is a matter that's created controversy over the years. I don't think it's appropriate for the Attorney General just to willy-nilly create special prosecutors. History has not shown that has always been a smart thing to do. But there are times when objectivity is required and the absolute appearance of objectivity is required, and perhaps a special prosecutor is appropriate. The Attorney General Lynch, for example, did not appoint a special prosecutor on the Clinton matter. And I did criticize that. I was a politician. We had a campaign on. I didn't research the law in depth. It was just a reaction as a senator of a concern. But there should be great care should be taken in deciding how to make the appointment or if an appointment of a special prosecutor is required. The Department of Justice, you're not required to be a judge, to be a prosecutor. One judge said there's nothing wrong with a prosecutor who likes his work and doesn't think laws should be violated. Is that a bias? I don't think so. I think that's a strength. So I just would say that's kind of the way, the best I could give you at this point, Senator Lee.
Thank you. No, that's helpful. Another challenging issue that relates to this duty of independence that attorneys general have relates to the Office of Legal Counsel. It's of course the job of the Office of Legal Counsel, or OLC as it's sometimes known, to issue opinions within the executive branch on a wide array of subjects. Some are subjects that a lot of people would find interesting. Others are subjects that only a lawyer could love, and sometimes only a lawyer specializing in something esoteric or specific. There's one recent OLC opinion entitled "Competitive Bidding Requirements under the Federal Federal Highway Aid Program." There aren't perhaps that many people who would find that interesting, but there are a lot of others that would capture immediately the public's interest. What's significant about all of these, though, no matter how broad or narrow the topic, no matter how politically sexy or dull the topic might be, they, in many instances, almost conclusively resolve a legal question within the executive branch of government. And in many instances, they're doing so on the basis of constitutional determinations that may or may not ever be litigated, such that the broaching of a constitutional topic might be opened, studied, and resolved entirely within the executive branch, largely as a result of how the lawyers within the Office of Legal Counsel decide to do their jobs. What can you tell me about what you would do, if confirmed, to ensure that the Office of Legal Counsel maintains a degree of professionalism and independence requisite for this task?
Senator Lee, that office is important. It does adjudicate or actually opine on important issues related to conflicts or disputes within the great executive branch of the American government. Like you said, what kind of competition is required before you get a highway grant? There may be a disagreement about that, and OLC is asked to review it and state one position, that the government of the United States is one. It's not a multiple government. These departments are not independent agencies. And so that office is so exceedingly important, as you indicate, because many times those opinions hold, and they set policy and they affect things. Sometimes it also has the power, and I'm sure you would be sensitive to expand or constrict the bureaucracies in their ability to execute under statutes. In other words, is this within their power or is it not within their power? So there's some of the things like that that can impact the American people over time in a significant way.
Senator
Thank you.
Klobuchar.
Thank you very much.
Senator Sessions, as you're aware, in many instances, Congress, when enacting a law, will choose to issue a broad sort of mandate, a broad aspirational statement, leaving the details of the actual lawmaking process to a regulatory system that then has to follow certain procedures in turn to effectively make laws. We call those regulations, typically. And sometimes an executive branch agency will go a step further. And outside the process that has to be followed when promulgating a new regulation, they'll just issue a guidance document outlining what the agency feels is the status of the law in this area. Guidance documents have received a lot of criticism from members of the public who point out that they are bereft of any kind of safeguard, and that they haven't gone through a legislative process. They haven't even gone through any type of review process that would normally accompany the regulatory rulemaking cycle. As a matter of policy making, will the Department of Justice, under your leadership, assuming you're confirmed, use guidance documents as a matter of course in promulgating legal interpretations?
Senator Lee, a guidance document that's clearly within the intent of Congress and the law's plain words can be beneficial. I think they're normally issued by the agency or department that administer it, like, for example, Health and Human Services, Homeland Security, Department of Commerce. Often or sometimes they ask the Office of Legal Counsel for their opinion about what the proper interpretation of a statute is. But I do think you raise a valid concern. A guidance document cannot amount to an amendment of a law. Bureaucrats do not have, that's a pejorative term, but department and agency attorneys and members don't have the ability to rewrite the law to make it say what they'd like it to say. And if we get away from that principle, we've eroded respect for law and the whole constitutional structure where Congress makes the laws, not the executive branch.
What about in the context of litigation, where you're litigating a case involving one of these guidance documents and you're representing the federal agency in question? Will the department, under your leadership, assuming you're confirmed to this position, ask courts to defer to non-binding guidance documents in the same way that courts are routinely asked to defer to regulations?
Well, that's a good question from a good lawyer, I have to say. In other words, the question you're suggesting is the established law of the land or the courts is that they give certain deference to well-established, properly established regulations issued pursuant to statute. But what if the secretary just issues a guidance document? Is the court entitled to give full deference to that? I would. First of all, I don't know. I haven't researched it. But I do think that would be a pretty bold step to go that far and would be dubious about it.
Thank you. As you know, from time to time, the Department of Justice receives subpoenas, or one of the entities being represented by the Department of Justice might receive requests from members of Congress, from committees in Congress, including some committees that have the power to issue subpoenas. In other instances, just letters or other types of requests from Congress for documents. I suspect that there may be a number of outstanding requests of this nature that are left pending at the end of this administration. Requests that were issued during the 114th Congress, the Congress previous to this one, but that will still need to be handled within the department after you're confirmed, assuming you are confirmed. Will you commit to reviewing any of those that remain pending and doing so in a manner that's timely and showing the respect for a coordinate branch of government?
Senator Lee, if you would, repeat for me that, but kind of
yeah, pending requests for documents that might be left over from the previous Congress.
Requests for documents in what kind of proceeding?
Requests for documents either from the department itself or in matters where the department is involved representing an entity within the federal government. I just want to make sure that those don't get left behind, that they don't get ignored simply because they haven't been dealt with by the previous administration.
Well, I do think they're entitled to be evaluated, and proper requests, I would assume, would continue to be valid, and we would try to follow whatever the law requires in that regard.
Thank you. I appreciate that. I want to talk about the use of the attorney-client privilege by members of the executive branch, by executive branch officials. In a 1998 opinion, the U.S. Court of Appeals for the D.C. Circuit reached the conclusion that executive branch officials do not enjoy the same common law attorney-client privilege as ordinary lawyers, lawyers who are not executive branch officials. Then Justice Scalia, while he was serving as the Assistant Attorney General over the Office of Legal Counsel, authored a legal opinion stating that executive branch officials do not enjoy the privilege unless they're dispensing with personal legal advice. Instead, in that view, executive branch officials need to exert the executive privilege rather than the traditional common law attorney-client privilege. And yet, executive branch agencies routinely can be observed asserting the attorney-client privilege instead of the in much the same way they would in the traditional context, rather than just invoking the executive privilege. Would you agree with that, that might raise some questions?
Senator Lee, I've not studied that opinion of Justice Scalia. I would be reluctant to comment, except I would say that it's probably good for the American Republic that department and agency officials seek legal advice before they act. In the long run, that's probably better. And I think having some expectation that they can have a candid comment with their attorney is of value. I hadn't thought about and never given study to the question of whether it should be under executive privilege or attorney-client, although I can imagine the difficulties.
Yes. No, I appreciate your candor on that point, and it gives me some comfort knowing that you're aware of the situation. You'll look at those. I'd like to talk about some antitrust issues in the moments I have remaining, and then perhaps we'll get back to these during a subsequent round. Antitrust regulators, when they're reviewing potentially anti-competitive harms that might arise as a result of a merger, will sometimes impose conditions on the merger moving forward, saying unless you do A, B, and C, this merger can't go forward, but if you do A, B, and C, in order to address whatever concerns we, the antitrust regulators, have, then the merger can be consummated. It is my view that there is a temptation for antitrust regulators sometimes to impose conditions that don't involve anti-competitive concerns, and that raises some red flags, that because the role of the antitrust regulator is to look out for anti-competitive concerns arising out of the merger, that's where their inquiry ought to be focused, and that's where their conditions ought to be focused. Do you disagree with that?
I would agree with that, as you formulated, I believe, and it would be wrong to further some other separate, discrete agenda that's not reasonably connected to the merger itself. So I think we should ensure that we have the highest integrity in antitrust adjudications because they can have great impact. The law is not crystal clear about what's lawful and what's not lawful and what the antitrust division is required to do, and it leaves dangers of, if not politicalization of it, it remains dangers of policy agendas getting embroiled in it. So it's an important division. It requires great integrity and ability, I believe, in the leadership at the Antitrust Division.
Thank you. I perked up when he started talking about federalism. And, of course, everything Senator Leahy said was interesting, but the federalism stuff is particularly interesting.
Your legislation.
Yes, exactly. I appreciated that, too. That was great. Federalism is an issue that's near and dear to many of us, and I know it's important to you. The notion that our federal government possesses powers that James Madison described as few and defined, and those reserved to the states are numerous and indefinite. We were supposed to be a different legislative body. Our federal government was always intended as a limited purpose national government, not a general purpose national government, one possessing complete police powers. We've seen a slow but steady drift over the last 80 years away from this principle of federalism, such that powers exercised at the federal level today could no longer be described as few and defined, but more appropriately described as numerous and indefinite. And in light of the supremacy clause in the Constitution, any powers we do exercise through the federal government are, by definition, replaced from the states. In other words, when our action conflicts with state action, it's our action that prevails in light of the supremacy clause. It's one of the reasons why federalism needs to be looked out for so carefully. One of the reasons why a view that I think you and I both share is that U.S. government officials in all three branches of government, whether they wear a black robe or not, are expected, when they swear an oath to uphold the Constitution, to look out for basic structural protections in the Constitution like federalism, so that we don't have an excessive accumulation of power in the hands of the few. So the Founding Fathers set up this system in which we have these structural protections. We have the vertical protection we call federalism, which we've just described, and the horizontal protection we call separation of powers. That says within the federal government, in order to protect us against the risks associated with the excessive accumulation of power in the hands of the few, we're going to have one branch that makes the laws, another branch that enforces the laws, and a third branch that interprets the laws. As long as we keep each branch within the same lane, the people are protected from what happens when one person or a group of people gets too powerful. But over the last 80 years, just as we've seen a deterioration of federalism, we've also seen a deterioration of separation of powers. You have an interesting set of circumstances with our laws, our controlled substances laws concerning marijuana, in that for the first time in a very long time, you've seen some attention paid to federalism, but in the limited area associated with marijuana. In other words, there are federal laws prohibiting the use of marijuana, the sale of marijuana, the production of marijuana, that apply regardless of whether a state has independently criminalized that drug, as every state until recently had. Then you had some states coming along and decriminalizing it, sometimes in the medical context, other times in a broader context. The response by the Department of Justice during the Obama administration has been interesting, and it's been different than it has in other areas. They've been slow to recognize principles of federalism elsewhere. They chose to recognize it here. My question to you is, did the way they respond to that federalism concern run afoul of separation of powers? Did the department's approach to this issue that they identified as a federalism issue contravene the understanding that we are the lawmaking body, the executive branch is the law enforcing body?
Well, I'm not sure I fully understand the point of your question, but you're talking about separation of powers within the federal government, the
Yes.
three branches of federal government.
Yes.
And how does that implicate the marijuana laws?
Yes. Are there separation of powers concerns arising out of the Department of Justice's current approach to state marijuana laws?
Well, I think one obvious concern is that the United States Congress has made the possession of marijuana in every state and distribution of it an illegal act. So if that's something is not desired any longer, Congress should pass a law to change the rule. It's not so much the Attorney General's job to decide what laws to enforce. We should do our job and enforce laws effectively as we're able.
Thank you. I'd like to get back to antitrust issues for a moment. In 2010, you co-sponsored some legislation that extended the Antitrust Division's leniency program and extended it all the way out to 2020. So it was a 10-year extension at the time. You helped move that through. The legislation provided that members of a cartel could receive reduced penalties if they reported cartel activity to the department and cooperated with any investigation the department had in connection with that antitrust cartel. Now, the Antitrust Division within the Department of Justice considers this tool, quote, its most important investigative tool for detecting cartel activity, close quote, because it creates an incentive for cartel members to self-report, to come forward and to identify things that the Antitrust Division needs to be aware of. So I applaud your leadership in this area because it's been very helpful to the enforcement of our antitrust laws of the Department. So I have two questions related to this program looking forward. First, given its importance, do you think the program should be made permanent? And second, are you open to any other ideas that might strengthen the program?
Senator Lee, I would not commit to you that I have formed an opinion on that. These are very complex areas of the law. I'm not a member of the Antitrust Subcommittee, as a number of members of our committee are, and have achieved levels of expertise like Senator Klobuchar and you and others. So I would just have to commit to you that I'm open to hearing the views of this Congress and that subcommittee, and would try to work with you. But I do understand that antitrust policy is an important issue for America, and we need to get it right, and that will be my goal.
Thank you. One important question that sometimes arises in the antitrust context relates to what role the Department of Justice should play in communicating with foreign authorities, authorities in other countries that deal with competition laws, deal with things analogous to our antitrust laws in this country. The Department of Justice has typically played a leading role, but in recent years it has also allowed the Federal Trade Commission, the FTC, to become heavily involved. To my mind, this raises some potential concerns because the FTC is an independent agency. As compared to the Department of Justice, of course, which is headed by a presidential appointee who, with Senate confirmation, serves at the pleasure of the President. Do you have any opinion on this, this point that the Department of Justice, which is more accountable to the President and therefore has some connection to the people, should be more actively involved in communicating with foreign antitrust or competition authorities?
I really wouldn't attempt to comment today on that. I would be glad to hear your thoughts on it. I think it can be problematic if U.S. officials encourage foreign officials to join with them against an action of a private company that could put so much excessive pressure on them that they're not able to resist, and when they may have a lawful basis to resist. But so these are big issues, and you have to be sensitive to the power that the Department of Justice has, the Antitrust Division has, and make sure that there's a principled policy and lawful basis for what is done.
Thank you, Senator Sessions.